Hey, welcome back to Kelly's Take Two review. We're about to dive into Unit 5 on transfer of title, which is just a fancy way of saying transfer of ownership when it comes to real property. So let's get started. All right, we're going to kick off today's mini lesson and review on how you may transfer property to another individual. This can happen one of two ways, essentially. Voluntarily because you want to, or involuntarily because you have to. Let's say it again. Transfer of title can happen voluntarily because you want to, or involuntarily because you have to. Which one sounds more fun? Yeah, I agree, voluntarily, but I digress. Voluntarily means you are going to transfer property either by gift or by sale. You might also will your property to another individual or family member or whatnot. Involuntarily would happen via death if you do not have a will, and we'll talk about that in just a minute. Foreclosure would be number 2 for involuntarily. Number 3, you might transfer title or ownership involuntarily via adverse possession. And number 4, you may involuntarily transfer title via something called eminent domain. And we'll get into those involuntarily aspects in just a moment. But before we do, it's probably a good idea just to talk about some language. So when the language that we use when it comes to real property and who the players are and what it's called, this language is so old, y'all. It is left over from the days of what? Chaucer, Beowulf. I'm talking King Arthur kind of days. You know what I'm saying? So really it would go down like this. Back in the olden days, let's say it was the time of Queen Elizabeth, for instance, who was so amazing, y'all. 40-year reign. Come on, Queen Elizabeth. She was something else. Okay. So let's say it's during Queen Elizabeth's day. Queen Elizabeth owns all the land in Great Britain, all the land. She is not going to sell it or give it away or anything. She might let someone use it, but she's going to remain in control of that land. She's going to retain ownership of that land. But how would she let somebody back in the olden days use it? Well, someone back then would need to have title. How did you get title? You would do a good deed. Oh, so if you did a good deed, the queen might grant you title. Once you had title, she would grant you a life estate. What does that mean? That means you could use the property while you were alive, but upon your death, ownership would transfer automatically right back to the queen. I love that. Okay. So when we talk about title, we're talking about ownership. When we talk about terms like grantor, the queen would grant somebody usage of that property. She would have been the grantor. The one who had the title, who did the good deed to earn the title, would be the grantee. And the grantee, just like a wide receiver in football, is going to receive title, receive ownership, and be quite happy about that normally. So in real estate school, if a word ends in OR, that person is giving something. So think of the OR being the giver. I wish giver had an OR. It would really make it work, but we'll try it. So the OR in real estate school is the giver. Think of it as the giver gives more. And maybe get kinesthetic with it and act like you're really picking up something heavy like a house and you're giving it away. Let's try it. Like the giver gives more. Whereas, okay, so that's the grantor. Let's do it again. So the grantor, you're lifting up a house, gives more. Whereas the one who's getting the house is the receiver. They receive this. They're the grantee. They receive the property. How do you think that makes them feel? Happy. Let's put all the dance moves together, shall we? So the grantor gives more. The grantee receives the property and feels happy. Okay, hopefully that'll help you with that vocabulary. All right, those are the players essentially. Now, what exactly is being transferred? We know ownership is being transferred. Title is being transferred. So title is the right to the property plus what? Plus the evidence. What do we call the evidence of ownership? The evidence of ownership is called a deed. Now, there are a few different types of deeds that could be shared when it comes to the sale of property. Let me share my screen with you. And we'll look at a graphic organizer that you can find in your supplemental materials right here. Hopefully you're seeing that. And we've got a general warranty deed at the top, a special warranty deed, quit claim deed, and I added a trustee's deed or sheriff's deed. You could also add a bargain and sale deed near quit claim. We might do that. We'll see. We'll think about that. All right, so I'm going to reference the deed section in your book, just in case we want to look at anything there. All right, let's dive in and talk about some features of the general warranty deed. Let's talk about this word warranty in general, y'all, first of all. When you think of a warranty, you might think of what? A warranty you might receive when you purchase a car, a warranty that you get for a certain type of an appliance. It's going to warrant the health of that vehicle. The health of that vehicle will be covered under that warranty. The same holds true with the ownership of your property. What kind of warranty is being given? Several. When it comes to a general warranty deed, there are a few. Actually, there are 5. You've got your covenant of season. Remember, the word season means ownership. There are several warranties that come with a general warranty deed. A general warranty deed offers the most promises, shall we say, inside of the deed. You've got your covenant of season. That means the current owner has the right to transfer this property, the full right to transfer this property. They are the rightful owners to that property. Whereas, let's say, for instance, you have somebody who owns property with 2 other partners, for instance, and maybe they own that property as tenants in common, like you learned about in a previous unit. Well, that one individual may not sell that entire parcel. That individual could only sell their piece of the pie. In order to sell the whole parcel, all 3 owners would have to sign off on that property's transfer. So the right of season, the covenant of season is number 1. Number 2, we have this covenant against encumbrances. Now that means future encumbrances, because it will tell you, it says here, the grantor warrants that the property is free from any liens or encumbrances, except those of record. So if we find an easement on file, for instance, that might be just A-okay, just ducky, but it means really a future encumbrance that might pop up out of the blue. Number 3 is the covenant of quiet enjoyment, meaning the property is being offered and be free of any future ownership claims. And number 4 is the covenant of further assurance, meaning if we've got an error in the deed, and we find that, then the grantor agrees to fix that and correct the mistake. And number 5 is a covenant of warranty forever. Forever, forever. What, Kelly, are you trying to tell me that I can own my property and as a 95-year-old person end up in court one day to defend the title of this property that I transferred to somebody else? Well, that's kind of extreme. So the short answer is no. But because you have title insurance, most people are going to have title insurance. We've got a certain level of comfort in offering this warranty forever. Title insurance, we're going to discuss in just a minute, so sit tight for that. Now, so your general warranty deed is the creme de la creme. It's that full, fat, delicious butter. That's what you want. That's what's typically going to transfer in most real estate transactions. That's the most common. And in fact, in the North Carolina Offer to Purchase and Contract Form 2T, it explicitly states that the grantor is transferring a general warranty deed. Now, you might encounter something called a special warranty deed, which is a little bit limited. So essentially, it's just saying that the grantor will defend the title for the time they've owned the property. They're not going to go way back in the historical record, but as far as they know, since they've owned the property, let's say it's 5 years, 6 years, 10 years, or whatnot, everything's a-okay. We shouldn't have any title defects. Very good. Next, let's talk about your quitclaim deed. Your quitclaim deed will tell you that the person transferring this type of a deed has no express or implied covenants or warranties at all. And your quitclaim deed is used primarily to convey something that's less than a fee simple situation, or it can be used to cure a title defect. Frequently, a quitclaim deed is used to in a divorce situation or to remove one homeowner from title, those sorts of things. Converse that or contrast that with a bargain and sale. In a bargain and sale deed, there is an implication that the grantor does hold title and possession to some degree, whereas a quitclaim deed, there is no implication at all. Nothing is implied, period. We know not a thing, essentially. Now, a sheriff's deed and a trustee's deed, and it looks like I spelled sheriff wrong. Looks like I need to get rid of one of those R's, don't you know? Okay, so pardon me on that. Thank you. But in a sheriff's deed will be used if there's some type of a court order, something like that. A sheriff's deed might be used in a foreclosure in a state that uses a mortgage for your debt instrument. Whereas in North Carolina, we use a deed of trust for a debt instrument, meaning a home loan. So if the property goes into foreclosure in North Carolina anyway, what will be issued is a trustee's deed, because the trustee, also known as the attorney, is holding that deed at the time. Very good. That's that part of Unit 5. Let's see. Let's talk about title and public records, and then we're going to get into title insurance in just a second, and we'll end talking about the Conor Act when it comes to Unit 5. Let me go ahead and stop sharing this though right now, because you don't need to see that. Okay, so next, we're going to discuss title and public records. In North Carolina, we are a first to record, first to be served kind of state. That means if you've got two people running to record some type of a deed or some type of a document, whoever gets there first and records wins, essentially. Also, the fact that we're a first to record, a first to be served type of state, that means that affects your lien priority, and in terms of which liens get paid off first, second, third, or fourth. Whoever records first gets paid first. Of course, always remember your property taxes, annual property taxes, along with any special assessment, if there is one, those will get paid first. They jump in line in front of everyone. Those are superior liens. They get paid right out of the gate, and just end the story right there. When we place documents into the public record, that's called giving the public constructive notice. That means that if a member of the public wanted to look for a certain type of document related to title or most other types of topics as well, using some really great due diligence on their part, some good sleuthing skills, they could find that information out. It's in the public record. On the other hand, we have something called actual notice, and actual notice would be more of that direct knowledge. So physically taking possession of a property, for instance, would be actual notice. A letter being sent to you via mail and one of those receipts that you received it, that would be actual notice. When you go to purchase a property, it is very wise and normally standard of practice that you're going to do some research on the health of that title. We call that chain of title. We want a nice, smooth chain of title from one owner to the next owner to the next owner. We should see that the owners are linked together from one to the next, forming a chain essentially. That might make you want to sing a little song like I do. I want to sing a little song when I hear chain of title. That makes me think of who? Aretha. Chain, 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 chain of title, chain of title. So we want to see the grantor, the grantee, the grantor, the grantee. We want to see those names repeated in a pattern over and over and over again. If there's a gap in the chain of title, if there's a blank space or the names don't line up right or some such thing while your person is researching the history of that ownership of title, we call that a gap in the chain of title. That's not what you want. That's frowny face. That's frowny face. Don't want that. So that's going to slow things down until we rectify that situation. Why? Because if you leave that gap open, that might give an individual an opportunity to pop up out of nowhere and what? Claim a piece of ownership. Might not be full ownership, but it could be a percentage, and any percentage of ownership could cause what? The forced sale of the property. So we don't like that. We don't like a gap in the chain of title. We want a smooth chain, 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 chain of title. That's what we want. Okay. They're going to go back how long? For 30 long years. We'll research the title. So they're going to research the title in North Carolina anyway, 30 years in the past. And then they're going to bring up those reports moving forward. Okay. So let's talk about that broken chain again. If there's a broken chain of title, we're going to go to court and file for a procedure called, or proceeding called, suit to quiet title. And you're going to need to bring evidence as to the research you've done to figure out what's going on. And the judge is going to settle that case for you before that property can transfer to another individual. All right, so let's talk about title insurance. How do you get title insurance? What is it? Why do I even want that? I'm going to share my screen with you. So go ahead and grab something with which to write. I think I'm going to type this time. Let's see if I can do that. Okay, let's make that a little bit bigger. Very good. Title insurance. Okay. Why? Why do you even want title insurance, first of all? Okay, well, you want title insurance to offer protection in the future against, it could be ownership claims, or ownership claims, deeds by minors. I'm just giving you a couple of examples. Undisclosed or missing heirs could be another one. Could be, let's see, deeds by persons lacking capacity or of unsound mind. Deeds by person of unsound mind, etc. There's a nice list in your book on page 99. There are 13 things actually that could be covered, instances where title insurance will step in and offer protection for the current homeowner. So that's why you want that. You want protection from future ownership claims, essentially. All right. So how do you, well, let's see. Who buys it? So who purchases? Title insurance is going to be purchased by the homeowner, the new homeowner. And they will pay for one policy for the bank. Yep, the bank's going to make them pay for that. And what will that cover? That will cover the loan amount. And then if they want to, they might get a policy for themselves. What would that cover? That would cover the difference between covers value above the home loan. So I might get a home loan for $200,000, but my house is worth $500,000. So I want that difference to be covered. Very good. Let's switch that up for a quick second and let's make this look a little tidier. There you go. Okay. Now, how do you get it? How to obtain. You will get your homeowner's insurance upon the closing of your new property. It will happen in just 4 easy steps. Number 1, you hire somebody to do the title research. In North Carolina, that's going to be an attorney. Then the attorney is going to write up something called an opinion of title, meaning it looks good. Okay, like hopefully they say, looks good. That's what we want. They're going to send that to the title insurance company. The title insurance company will issue a commitment of title. So a commit, I think that's 1T, commitment of title issued. Now it's not the real thing yet. Why? Because you don't own the property yet. And then the attorney or the title company is going to put together a final, will submit a final opinion of title directly after closing on the property. And after that, then the insurance is issued. There you go. Excuse me. There is so much pollen in the air right now, is there not? All right, very good. Now, your title insurance, again, is going to cover future events from happening. And I listed a few of them up top. Like I said, there are 13 scenarios outlined for you in your book on page 99 if you wanted to look that over and see what's covered. Number last that we're going to discuss today out of Unit 5 is the importance of recording your documents at the Register of Deeds office. It's a big deal. It's a big deal to record your documents. Why? Recording your documents offers protection against what? Future ownership claims. So I'm going to go ahead and clear my board and I'll be right with you. We're going to write something else down. So I'm going to keep this screen right here. Actually, let me talk to you first, and then I'll write something down. So in North Carolina, we have something called the Conor Act. And the Conor Act was created, seriously, by Judge Henry Conor in the late 1800s to help alleviate so many ownership lawsuits that kept coming before his court. He was starting to get a little bit aggravated. I'm making that up, but you know. So he's getting aggravated. Everyone's having these ownership claims and fighting who owns this land, who owns that land. He said, look, we have got to come up with some kind of a solution here. I am sick of all of these court cases. Why? How would this happen? Well, you might have, let me see if I can get a little piece of paper. Let's pretend that you've got one individual and they come to court and they say, hey, I've got this deed that so-and-so gave to me, the grantor gave to me, so I own this land. And another individual will come up and say, I have a deed over here. I have one for that same parcel that the same person gave to me. Mine's better. Mine's a better deed. So you'd have two parties each claiming ownership to a parcel of property, and it caused just so many headaches. So that's when Judge Conor said, let's do this. Whoever takes their purported deed and gets it recorded at the Register of Deeds office first wins. That's the main rule. Okay, so whoever gets there first, they're racing down to the courthouse to record, they're going to be the owner. Now, I'm going to go deep here for just 2 seconds. Forgive me, but it just makes sense to do so, really. Okay. So I have a deed that seems to be a correct and proper deed. This other person has a deed. It seems to be a correct and proper deed. This person runs to the courthouse. They get it recorded first. They claim they're the rightful owner. But I disagree over here. I say, I have one too. Mine's just as good. Mine's better. Mine's better. I'm the rightful owner. Well, this person's going to go to court, of course, and go before the judge and say, not only do I have this proper deed right here, but I've been living on this land for more than 7 years. This person has been living on the land. I've been living on the land for more than 7 years. Plus, I have this document that I truly believe is my correct deed. I'm the rightful owner to this property. There is a chance that this person could win. They could win. Why? Because they've been on the land physically for more than 7 years. They have some document that looks to be real, that looks to be authentic. They have reason to believe they should be the owner. They might win, and that's called a color of title suit. A color of title suit. Very good. But that's how we came up with this whole recording of your deed, recording of documents to try to cut back on these lawsuits that were happening. So in North Carolina, there are a few items, few documents, real estate related, that need to be recorded at the Register of Deeds office in order to offer protection against third parties. There are 8. Should I type it? I think I'll type it again. Let me know in the comments if you prefer typing or writing. It won't hurt my feelings. This is good feedback. Okay, so there are 8 RE, that stands for real estate. Real estate, let's call them instruments, because that's the real word in real estate school. Instruments, which really means what? Documents. Needed 8 real estate instruments need to be recorded in order what? In order to offer protection against future ownership claims. We might add third party into that if you want to. Third party ownership claims. All right, very nice. Okay, what are those 8? Number 1, deeds. Number 2, mortgages. Of course, in North Carolina, we call that a deed of trust. Number 3, installment contracts. You haven't even learned about those. That's not till Unit 10. Those are kind of like rent to own situations. It's an easy way to think about that. Number 4, contract assignments. Number 5, that's also unit, I believe that's Unit 10. Option contracts. That's Unit 10. Number 6, leases for more than 3 years. That's going to be unit 11. Easements, you already learned about easements. And 8, restrictive covenants or covenants and restrictions. Covenants. Okay, very good. So those need to be recorded in order to protect against future ownership claims and to be enforceable in court as well. Very good. Okay, give me 2 seconds. Let me make sure I didn't miss anything under that. All right, I thought so. That should be an A. Thank you very much. Oh, and then an N. So I knew something didn't look right. Covenants, restrictive covenants. Okay, is that correct? Let me double check. Yes, okay. Well done. This would show up on the North Carolina side of the exam because this is North Carolina specific, just so you guys know. Let's see if we want to add that anywhere. 8 real estate instruments need to be recorded in NC. Let's put NC. In order. I don't know what I did, y'all. Maybe I'll handwrite this next time. Oh, I see. Oh, it's doing something really interesting. Okay. We'll just leave it like that for a minute. I must have pressed some kind of funny button. But there you go. So your 8 real estate instruments that need to be recorded in North Carolina in order to offer the most protection would be deeds, mortgages, installment contracts, contract assignments, option contracts, leases for more than 3 years, easements, and restrictive covenants. And that's where we're going to end our Unit 5 Take 2 review. You have a great day, and I'll see you next time.